It is a pleasure to introduce you to the Burton Book Review podcast, with interviews of America's leading authors by our nation's finest law professors and scholars. Each podcast is featured on the American Bar Association Journal and on theburtonbookreview.com. And now, to our program.
Good afternoon. My name is MaryAnne Lavan. I'm the retired General Counsel of Lockheed Martin, and I'm privileged to be joined today by Professor Marc Steinberg, who's the author of Corporate Director and Officer Liability, Discretionaries, Not Fiduciaries. Professor Steinberg is the Radford Chair in Law and Professor of Law at Southern Methodist University. He's a very prolific author. I'm so amazed. 50 books and over 150 law journals. So congratulations on all that work, and thank you for joining us today.
Well, thank you. Thanks for having me on the podcast.
Great. Well, my first question was, with all your books and law journals, why this book and why now?
Sure. I've been in academia a good amount of time. I started my career as an SEC enforcement attorney. Then a few years after that, I went into academia. I've been literally teaching the subject matter since 1982. And what struck me was that although corporate directors and officers are called fiduciaries, the legal standards that apply with respect to liability are not, in fact, fiduciary. That over the years, the law has become more permissive with respect to several issues, and particularly with respect to the exculpation statutes as a key example. And a few years ago, as these exculpation statutes became more and more proliferated, it struck me that we're calling these directors and officers fiduciaries. Well, in fact, they're not. And that once we really look at reality, this term is really a misnomer. And it should be replaced with a more accurate term. And the term that I've created is the term discretionary. That directors and officers are discretionaries, that at times they have fairly limited discretion, like in certain self-dealing transactions, while in other contexts, their discretion is extremely broad, and there's no liability, in fact, unless these individuals engage in fraud.
So do you, when I was reading it, I was wondering, you think it's the director's understanding of their liabilities, or it's the court's interpretation and then the misuse of the label in your mind?
Well, I think there's a distinction between standards of conduct and standards of liability. Standards of conduct, we see this, for example, in the ABA's motto, professional business enterprise code, and that is that you look at section 8.30 of the Model Business Corporation Act. That's the term I was looking for, the Model Business Corporation Act. What we see is that directors and officers in another section are really to exercise reasonable care, good faith, adhere to the duty of loyalty. And we see this in numerous Delaware court decisions as well, that directors and officers owe an unyielding duty of loyalty, for example. These are standards of conduct as the Model Business Corporation Act makes clear, and the Delaware courts have made clear. These are not standards of liability. They only reflect best practices. When we look at standards of liability, though, with respect to under what circumstances will a director or officer in fact be held financially liable, then we have far more lax standards applying. In my view, directors and officers, for the most part, seek to adhere to best practices. In other words, standards of conduct. Good corporate counsel, of course, both inside counsel and outside counsel, advise their clients with respect to adherence to standards of conduct. But when those standards of conduct are not met, there are no legal consequences with respect to them, that there's only adverse legal ramifications if the standard of liability, which is far more lax, is not met.
You know, that's interesting. You raised some interesting points, because as a corporate counsel, Limited to obviously my board of directors, and I sit on some nonprofit and for-profit boards. But I think the board members understand their duties as fiduciaries. But your point is that's the standard of conduct. That's not necessarily the right language when it gets to the liability portion of it in court. But then it made me wonder, was I properly advising the board of directors, or were they being properly advised that their duties were fiduciary and not just, I don't think I ever used the term discretionary. So that leads me to my question. Who do you think your major audience was for this, and who
Sure,
should be trained and how to go about it? I mean, that's
sure,
multiple questions, so
sure.
sorry
Let
about
me
that.
let me just step back for a moment, though, and reply to the point you made in part, and that is that state company law is not the only player here. In other words, when you advise your client with respect to standards of conduct, that was certainly good legal advice, because after all, we have federal statutes applying. We have perhaps in certain contexts SEC rules applying that legally require far more normative sound conduct as a matter of law than do the corporate statutes and court decisions with respect to company law. So that, yes, directors and officers, when we look at company law, are not fiduciaries. But the fact of the matter is that standards of conduct are not irrelevant. They are indeed relevant because they seek as much as one can do assurance that the law is being complied with, irrespective of the particular statute. And secondly, that is the way in which that there is the opportunity for profit maximization for the corporation and its shareholders while complying with the law. So that standards of conduct are indeed relevant. I by no means suggest that they are irrelevant. They're very important. With respect to my audience, I think, of course, are judges. After all, they're the decision makers here. That they are perpetrating the misperception that directors and officers are fiduciaries when they are applying the business judgment rule, when they're applying the duty of care, when they're applying the termination of derivative suits, and when they're interpreting the particular exculpation statutes. Applying these standards, applying gross negligence levels of culpability, applying recklessness levels, applying intentional misconduct levels, that is not within the boundaries of fiduciary conduct. In fact, if you and I were to engage in gross negligence, for example, we were driving our cars, or engaging in other type of personal action, we were to perpetrate gross negligence, we'd be subject in many states to punitive damages. But yet, that's the level of culpability that's required under the business judgment rule. And on top of that, most of these publicly held corporations, and I'm just stating this as a matter of fact, have exculpation provisions, which does not, and these statutes do not permit the levying of monetary liability absent a breach of the duty of loyalty, unless directors and officers engage in intentional misconduct. So that under these statutes, even reckless misconduct, so long as the duty of loyalty is not implicated, that type of misconduct is not actionable.
So if there were so the changes though to discretionary would have to be, would it be case by case? Would it be statutory? I'm trying to understand how best to train the board of directors or people who are potential board of directors, what their responsibilities are.
Right. I personally believe, of course, that the standard of conduct is extremely important. That the standard of conduct is set forth in the Model Business Corporation Act, as set forth in Delaware court decisions, as another example. Those should be adhered to, because by complying with those standards, then there's far greater assurance that irrespective of the statute that's implicated, the law is being complied with. Moreover, these these standards of conduct, they represent good corporate governance. And studies have shown that when corporations are engaged in sound corporate governance, then it's more likely that the corporation would be operated in a profit maximization role while complying with the law. So if I were counsel to a board, I would stress best best practices, the standard of conduct. However, again, with respect to the liability exposure, the liability exposure is not fiduciary in nature for the most part. There are certain exceptions. For example, Texas passed a statute this past summer that even in duty of loyalty cases, that in order to hold a director or officer liable, a plaintiff must show intentional misconduct, fraud, a knowing violation of the law, or an ultra vires act. So we're talking about even in a corporate opportunity situation, even in a director self-dealing situation where the duty of loyalty is clearly involved, there would be no liability unless it can be proven that fraud or intentional misconduct or a knowing violation of law is involved. To say that that's a fiduciary standard, of course, belies reality.
So I see you're saying, with the standard of conducts, if the board members comply with the standard of conduct, in most cases they are fiduciary duties. But if it gets to the courts almost give them additional protection because the standard is so high to find liability. Is that essentially what you're saying? That it's not fair to the stockholder, that if there is a breach of that standard of conduct, that in fact there won't be any liability?
Well, with respect to the standard of conduct, I don't equate it with viewing these people as fiduciaries or not. From the standpoint that the true measure, for the most part, is what are the legal ramifications if a responsible person acts in a specified manner that allegedly is deemed to be improper. When perhaps you and I took business enterprise in law school, the interested director transactions, they had meaning. It was on the onus of the director who benefited from the transaction to show that it was fair. That when there was a situation with the duty of care, even though the duty of care is a very hard case to prove, courts applied an ordinary negligence level. Today in Delaware, to show a violation of the duty of care, gross negligence must be shown. The right of a shareholder to pursue a derivative action was far more protective of the shareholder's ability to do so than today. So that when you look at these standards, to me, whether one is fiduciary, the question is under what circumstances will that person's conduct be deemed to be actionable? If the standards are so lax that they do not represent fiduciary status, and what is fiduciary status? Well, according to Black's Law Dictionary, that's probably as good a definition as any. A fiduciary is deemed to be a person who is required to act with reasonable care, in good faith, and with loyalty to those persons to whom the duty is owed. If we look at state company law, that's not the situation. Those directors can act with gross negligence. They can act. Well, the lack of good faith was actionable, but it requires intentional misconduct to violate the duty of good faith. And then the duty of loyalty has been severely diluted to the extent that in many states, including Delaware, corporate opportunities can be taken by directors and officers that are within the sweet zone of a corporate opportunity in the best interest of the corporation if the board promulgates a bylaw permitting that to happen. So that to call these people fiduciaries when these are the legal standards that apply with respect to liability, I think is a misnomer.
You made the point that Texas just passed a statute this past summer. So this book is so well researched, and we'll get to that in a little bit about the methods about that. But
Well,
how do you keep? Go ahead.
thank you
Sorry.
very much. By the way, It won the Best Business Book reference by American Book Fest for 2025, I'm happy to say.
That's great.
Thank you.
Congratulations. But how do you keep it a living document since it seems to be changing all the time in terms of it was in 2025, but there's probably been statutes. How do you keep it up to date for people who want to go and sort of figure out what's going on in their state?
Yes, well, it's certainly, this is an Oxford University Press book, so it's certainly not a least loose leaf service. But what has happened, in fact, since the publication of this book, which was last June, is that state developments have in fact reinforced these concepts. So what I say here is still very valid, and the Texas statute, for example, provides further support for the positions I take. But to answer your question, I don't think, given what happened in Texas, that's going to happen in a book itself. But I'm now in the process of writing a law review article that, in part, discusses the Texas statute and and elaborates upon many of the themes that I raised in this book.
Yeah, that's an interesting point. So that was going to be my other question. How do you distinguish when you're writing something, obviously something of great interest? How do you distinguish whether it's going to be a book or a law review article? Because one could argue that this book is a very, very, very long law review article because the basic, the carefulness and the citations. So how do you distinguish that?
Well, one depends upon whether I feel like writing a book about it, because after all, a book is a much more substantive and time-consuming process. Number two is whether there is a good audience for the book and a good publisher. Uh, when when I have Oxford extending me a contract, then I consider that a good publisher. And then the impact that I may have on the development of the law. And frequently, at least in this context, a book may have greater impact than an article would.
Hmm.
For example, I've published authored three books with Oxford in the last 7 years, and they all have very broad themes. The first was in 2018, the federalization of corporate governance, which focused on the evolution of corporate governance going from the states to the federal government. We think of the Sarbanes-Oxley Act, of course, but there was federal incorporation of corporate governance way before that. Just think about insider trading. Insider trading is a matter of federal law, yet this is within the sweet zone of the duty of loyalty, and yet the states refuse to police it. And then, with my focus very much being on securities law, I have the strong opinion that the securities laws need great revision. And I wrote a book in 2021, which won the best book in the country by American Book Fest for 2021, Rethinking Securities Law. So there I looked at our securities laws and pointed out what I thought was wrong with them, and then made recommendations for reform. And then this book, Corporate Directors and Officer Liability, basically put, I am just tired of courts calling these individuals fiduciaries when they in fact are not. The law is being untruthful here. And it is appropriate to basically call the situation for what it is. That these individuals are well-meaning for the most part. They seek to adhere to standards of conduct, but when it comes to the liability exposure, very lax standards that apply, in fact, that are not in any way fiduciary in nature for the most part, and that therefore a neutral and accurate term should be adopted. And I've come up with the term discretionaries.
Hmm. Have you received any direct input from any judges on, basically you're saying they're applying a different they are under the guise of fiduciary duty are applying a standard that is too liberal.
Well, for example, in the back cover of the book,
Right.
Vice Chancellor Laster, who's a sitting judge on the Delaware Court of Chancery, he stated, and I quote, Professor Steinberg goes beneath the surface to look unflinchingly at how the law operates and makes a powerful case that the fiduciary headline doesn't match the story. So the judges are aware of it. They've told me they find the book interesting. I'm just waiting for them to cite the book and adopt the term. And I'm
Yeah, I
hoping
was
that
going to
will
ask
happen,
you.
although, of course, I recognize there's no assurance.
Right. I wonder if Judge Laster has changed any of his opinions that have come out.
Not that I'm aware of.
Okay, well, that would be interesting. And right, if you're cited in any of the opinions, that would be really interesting. That would be sort of the biggest accomplishment I can imagine.
Well,
How long did it take you to write the book?
oh, it took me about a year and a half, I'd say.
Yeah,
Of course, I
yeah,
was doing other things in addition,
of
but it took
course.
about a
But
year and
it's
a half.
do you use it to teach your courses?
No, this is a research book. This is a book for judges, for professors, for attorneys who want to read up on this, and I imagine for law students who want to know what I'm thinking before they take the final examination.
That's probably very good. They're probably reviewing it very carefully. Did you have any assistants, any law students helping you with the book? Because it sounds like it would be a really interesting project.
Not with the research per se. The only help I really had were on two distinct subjects. One is the statement that the law should be truthful. Can you believe that it's hard to find support for that simple statement, which is really a fundamental component of the rule of law? But yet, it is hard to find a a a renowned commentator simply saying, or a court decision saying the law should be truthful. And and there were a couple of sources found. And in fact, we found the source, my research assistant from Sandra Day O'Connor, the former justice of the Supreme Court. So that was used. And then the only other part I used a research assistant was I wanted to see how many times the Supreme Court in its decisions referred to corporate directors and officers as fiduciaries.
Mm,
So I have a chapter here on the U.S. securities laws as well, because the Supreme Court numerous times uh, has called directors and officers fiduciaries, but yet when you look at the liability standards and with respect to nearly all the provisions of the securities laws, the Supreme Court has required that intent be required to be shown by the plaintiffs or by the SEC. So that is also a chapter included to show that not only the states but the SEC and the federal courts use this term as well, and it is not a correctly used term given the liability standards that apply.
hmm It's interesting. I know
But
in Washington.
otherwise, I wrote every sentence of this book, every footnote of this book by myself. And what it is, of course, is just like with your bless you, just like with your wonderful career. We're saying I've been involved with this since 1978. I mean, that's a long run. Even when I
Right.
say I began this when I was 10 years old, that still puts me in my 50s. Uh, so uh, so in any event, I've had a long run at this, so it's more or less I know this stuff in my sleep just
Sure.
from having written the amount that I have, and I thought about it for decades.
Yeah.
So for me to sit down and write this, it wasn't as if I was trying to define a new scientific discovery, so to speak. That I
Sure.
knew what I wanted to say, and of course, it took time to compose it, but I had very much in my mind what I wanted to cover in the book and what my positions are.
That's great. Well, you certainly are an expert. Have you ever been called as an expert on this particular issue yet, or that's to come?
Oh, many times. I mean, I've been doing expert witness work since 1986. I was retained by the University of California in the Enron case, which involved this, uh, and uh, and a number of fiduciary duty corporate governance actions. I'm involved, retained by both defendants and plaintiffs on a fairly regular basis.
Great. That's great. So what's your next project? If you can tell us.
Well, my next project is hopefully writing a book. We have chapters uh, drafted so far on a book on the Texas Gulf software decision. You remember that decision? It's a seminal insider trading case that really federalized the law of insider trading. And it not only federalized the law of insider trading, it dealt with a number of other concepts, such as materiality, such as when insiders may properly trade, such as corporate liability for misleading statements, such as by means of a press release in the secondary trading markets. So the book's basically an experiential book that will talk about the law and that will also include documents from that case. So hopefully it will make a good contribution to the law in this area.
Yes, I'm sure it'll catch people's interest because it's one of the in some respects it's a thing people can understand very easily, but in terms of applying it to specific facts, it can be problematic. So
Yeah,
that should be good.
I might add, when I travel abroad and I'm asked what subject that I should lecture on, uh, the subject of insider trading is an easy one, for the reason that whether one is a specialist in corporate or securities law or is not, that is a topic that attracts attention and interest across the spectrum, no matter what field an attorney is specialized in, or for that matter, with respect to students. Everybody seems to be interested in insider trading.
Well, because it could just catch somebody totally unaware, and you get caught up in the whole issue without if you're not careful. So it is, and it's. I think it is something that people can understand pretty easily. Probably see it in movies and that kind of thing.
Exactly.
Fiduciary duties and discretionaries probably is not the subject of a the most most recent TV show or movie.
Are you suggesting that this topic will not put people on the edge of their seat?
For many people, it will, but for people who are sort of used to that instant gratification, I'm not so sure.
Well, we'll see whether it merits an encore with a second book in the next few years.
That's great. Well, one final question then, well, actually two final questions. One is outside of legal writing. Well, is there a legal beside yourself? Is there a legal writer that you highly respect? And then outside of legal writing, if you even have time, do you do any reading, non-legal reading? And what's your favorite genre?
Right. Well, as far as other professors who write, I mean, I read their material, but no one person uh, jumps out at me. What I try to do is look at a diversity of viewpoints,
Mhm.
because after all, I think that makes my views more balanced. With respect to areas outside of the law, I'm a huge sports fan. I have baseball cards I collect. I like autographs uh, and uh, and political memorabilia. And generally, I will read sports books or books about history, especially, for example, World War II, uh, some novels. Uh, but basically, that's what I do. So, and of course, I like going to events and play a lot of tennis still. I like sporting events, so try to keep myself active. That's the key,
That
and
is the key.
hopefully, I can keep on going for a long while.
Oh, I'm sure you will.
That's
I'm sure
certainly
you
the
will.
plan. Hopefully, God is willing to treat
Yes.
me well.
Yes. And then a final question, sort of a catch-all. Is there anything that I didn't ask that you want to talk about, or hoping that I would ask, or hoping I didn't ask?
This has been great. Thank you so much, and again, congratulations on your superlative career. Uh,
Oh, well, I was fortunate to be part of a great team. So,
So I just want to point out and just emphasize one point that was made earlier, and that is, what's the big deal here? So they're called fiduciaries. What difference does it make? And to me, it's important. And the importance is, again, it's the law should be truthful. We're calling these individuals fiduciaries. They are well-meaning for the most part. They adhere to best practices, standards of conduct. But yet, when we look at when they're to be held liable, normally very lax standards apply. They are not fiduciary in nature. The law should be truthful. The legal principles should be applied in such a way that the label that these three people are identified by should be accurate. And they are not fiduciaries. A neutral and accurate term should be used. And I've come up with the term discretionaries. Hopefully that's acceptable. The other point is that we are having more and more retail investors enter the marketplace. Uh, Many of these people are not financially sophisticated. When they look at corporate directors and officers, especially boards of directors, being viewed as fiduciaries, they may reasonably believe that these individuals must adhere to higher standards than in fact exist. This may mislead these investors. It may cause them to feel that these individuals are receiving preferential treatment. I'm not suggesting that retail investors will leave the marketplace. After all, they're basically concerned with good financial returns. But what I'm saying is that if we're going to enhance investor protection, if we're going to basically try to adhere to good market practices here, what we should do is basically have legal standards apply that accurately describe uh, the contents which form the principles at play. So that, again, when one views a person as a fiduciary, whether it's an attorney, whether it's uh, uh, whether it's the trustee, one thinks of a person that must act with great care, at least reasonable care, in good faith, and with a strong sense of the duty of loyalty. This is not the case here, and that therefore the term should be adjusted so that it reflects reality. The term discretionary, I think, does that. And therefore, there has been full disclosure to all participants of exactly what legal standards directors and officers must adhere to.
That's great. If I were to name this podcast, it could be "The Law Should Be Truthful." How's that?
Yes, I agree. The law should be truthful.
Truthful. Yep. That's great. Well, I appreciate your time today, and I appreciate all your contributions to the legal profession. They're really outstanding. So thank you for your time today and
Well,
for all
thank
your
you.
efforts.
You've been very kind to me. I appreciate it, and I'm honored to be on this podcast. All the
Oh,
best
great.
to you.
You too. Thanks.
Thank you.